My guess is that at some point in time, you have gotten a fax at work or elsewhere that you never wanted, advertising a service you had no interest in. Well, you know there's federal law that prohibits unsolicited faxes from being generally sent out to people. But the question is, how does that law really work? Well, that takes us to this week's case. It involves a man, interestingly enough, who was a lawyer, and he was advertising his services. And he was doing that through having faxes sent to accountants because he was involved in financial planning and tax work. He had the faxes sent by a public relations firm, and they were generally distributed to accountants throughout the country. Well, these folks weren't happy with that, and a class action was brought. It went to trial, and lo and behold, it was found that he violated the federal law because he didn't have an opt-out position on the faxes that he was sending out, and as such, he was hit with the statutory damages, which are $500 per unsolicited fax. Now, these faxes had gone out to over 8,000 people. His damages were assessed at $4.2 million, and he said, ouch, ouch, I'm going to appeal this case. So it went up to the 7th Circuit Court of Appeals for the United States. And there the argument was very simple. He said, you know what? I sent out these faxes, and these faxes basically are telling accountants about how the law works and certain accounting principles. And just a small amount of the fax actually dealt with a plug for me, because the majority of the fax, 75% of what was contained in the fax that went out, was just dealing with the law and legal issues that accountants may be interested in. Only 25% of it dealt with any kind of a mention of my practice and what I did. Therefore, I contend that this was not an advertisement. This was simply a public service I was performing to the accounting community. Well, the court heard his argument. The court heard his argument. They pondered it and said, you guess what? Even though only 25% of it was dealing with a plug for you, 75% of it sure was dealing with providing general information regarding the law and things that may be of interest to accountants. The fact is that that 25% constituted an ad, and therefore we find the fax was an ad, and therefore we find that you do owe the $4.2 million. Now, the court remanded it back to the trial court for consideration of whether or not this attorney out of Chicago could actually afford the $4.2 million, or whether a different punishment needed to be imposed upon him. So what do we learn from this? What do we learn from this? We learn that, number one, as you may have already been aware, when faxes come your way, if you don't want them, you need to have the opportunity to opt out. There should be an indication on the fax as to who you can contact to prevent those faxes from coming to you. And number two, if in fact those faxes are still coming through your fax machine, you do have a right to bring action, to sue the person. It has to be done in civil law, to sue the person and seek statutory damages. You don't even have to show that you were harmed in any way. All you have to do is show that you were getting these faxes and you never wanted them, and the statutory damages, as we said, are $500 per unsolicited fax. Okay, so today you get the facts, the facts of this case, as we bring you facts of every case every week so you understand how the law works. I'm David Allen.